Hello everyone, welcome to Dr. Rajkumar's Learning app. In this session, we are going to discuss about the Judiciary of India. We know the history of our country that the judiciary is not new for us. When the time period of Chanakya itself, before the Mauryan Empire, and after the Mauryan Empire. Hello everyone, welcome to Dr. Rajkumar's Learning app. In this session, we are going to discuss about the judiciary in India. Judiciary in India, it's not new for us. From the ancient time period, it was there, were maintained by different empires in the ancient time, as well as the Mughals and Delhi Sultans in the time period of medieval. Later on, British came to India. Okay, British came to India in the form of East Indian Company. Okay, when they entered in the year of 1608, some 1770s, still 1770s, they did a very good trade and commerce activity with our country. But there was a corruption which is in the East Indian Company. So the British Parliament wanted to cut all the corruption activity. That is the reason behind coming up with the Regulating Act of 1773. As per that, 1774, the first Supreme Court was established in Calcutta for the trials subjects of the British alone. The company employees who are working for that, civil and criminal charges will be, any criminal charges against them will be taken care by that Supreme Court. That is the purpose of establishment of the court here in India by the British. So that followed after the independence, how we altered the system of judiciary. And also 1935 Act gave the Federal Court for India. Which gave the Federal Court for India. That is, now we used to call it a Supreme Court located in Delhi. Okay, right. So 1935 is the time period that Federal Court of India came into existence at Delhi. So now after the independence, as per the provisions of our Indian Constitution, what are the things comes under your judiciary? That is what we are going to discuss in this chapter. Okay. The Indian judiciary administers a common law legal jurisdiction system. Okay, legal jurisdiction system, which customs, precedents and laws all codify land of the law. Because we have jurisdiction in the court system. We have local courts, high court as well as the Supreme Court. Supreme Court has a jurisdiction throughout the country, and the high court used to have the jurisdiction only for that particular state. So in India, there are different levels of justice, that is different types of courts we have, each with the different powers and depending on the level and jurisdiction given to them. Okay, they form a strict hierarchy of precedence in accordance with the court order in which they sit. In India, Supreme Court at the top level, followed by that we have high courts of the respective states with the district judges sitting at the bottom of the district courts, and second class magistrates and civil judge. So you can call it a Supreme Court as a top level. Then we have High Court, the next level. Then we have district courts and some subordinate courts. So we are following a proper structure in terms of judiciary in our country. Okay. So the Supreme Court of India, first we are going to discuss. The present day Supreme Court of India started functioning on January 28, 1950. Remember the date? January 28, 1950 is the first functioning time period of our Supreme Court here in India. That is after independence. Its predecessor was the Federal Court of India, which was created as per the Government of India Act 1935 by the British Parliament. I told you this point earlier. As per 1935 Act, Federal Court was created at Delhi. That is the Supreme Court in the current day. Article 124 to 147. Article 124 to 147 in Part 5 of the Indian Constitution completely deal with the organization of the independence, jurisdiction, powers and procedures of the Supreme Court. At present, the strength of the Supreme Court judge at 32 judges. 32 judges, 1 Chief Justice and 31 other judges. Okay, so current strength of the Supreme Court judges around 32. Originally, the strength of the Supreme Court was fixed at 8, 1 Chief Justice and 7 other judges for one bench. Okay, bench differs from one case to another case. In 2015, there was a committee declared the Supreme Court, and hence the collegium system still holds the selection process of the judges. So that committee was established in the year of 2015, named called the National Judicial Appointment Commission. Okay, National Judicial Appointment Commission, NJAC. Qualification to be a judge. A person to be appointed as a judge of the Supreme Court should have the following qualifications. One is, he should be a citizen of India. He should have been a judge of High Court or High Court in succession for 5 years. He is supposed to work as the High Court for how many years? 5 years. He should have been advocate of High Court. Okay, advocate or High Courts in the succession for how many years? 10 years. He should be distinguished jurist in the opinion of the President. These are all the qualifications to elect as the judge of the Supreme Court. About the oath. The oath of the judge and the CJI is administered by the President or any other person appointed by him for this purpose. So whenever there was a selection of judge of Supreme Court and Chief Justice of India, the oath ceremony will happen under the control of President. In case of no President means any other person will be appointed. Okay. Tenure of judges. He holds office until he attains 65 years. He can resign by his office by writing his resignation letter to the President of India. He can be removed from his office by the President on the recommendation of Parliament only. Okay, when Parliament recommends the President of India to remove the judge of Supreme Court, on that recommendation only they'll remove. Okay, so removal of judges, what are the procedures? A judge of Supreme Court, a judge of the Supreme Court can be removed from his office by an order of the President. However, he can do so only after an address by the Parliament, as being presented to him in the same session for such removal. Okay, so what President is supposed to do? He is supposed to address the Parliament related to the removal of the Supreme Court judge. The address must be supported by a special majority of each house of the Parliament. So, removal of Chief Justice of India, both the House, Rajya Sabha and Lok Sabha, that particular resolution is supposed to pass with the special majority. Okay, special majority, that is 2/3 of the members of the House supposed to present, and they need to give their oath related to the removal of the judge. The ground of removal are proved misbehavior or incapacity. The removal process of both the Supreme Court and High Court contain same. Okay. So the jurisdiction and powers of the Supreme Court can be classified into original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory jurisdiction, a court of record and so on. Okay. Make sure original jurisdiction. Okay. Next one is writ jurisdiction. Next one is appealing and advisory. These are all the jurisdiction and powers of the Supreme Court. What is original jurisdiction? When the case is involved between the center and the state, or two or more states, or center or two or more states, which is known as original jurisdiction. The case which used to originate in the Supreme Court itself for the center as well as the state. One or two other states used to be there. The first such instance came in the year of 1961. West Bengal was the center, which is known as original jurisdiction. The Constitution has constituted the Supreme Court as the guarantor and a defender of the fundamental rights of the citizens, which is known as writ jurisdiction. The Supreme Court is empowered to issue the writs including habeas corpus, mandamus, prohibition, quo warranto, certiorari for the enforcement of fundamental rights of an aggrieved citizen. If any aggrieved citizen who is not addressed the proper fundamental rights for him, he can go and approach the Supreme Court. So Supreme Court can issue the writ petition based on the all the 5 criteria. Okay, so the difference between the Supreme Court and High Court jurisdiction is that The Supreme Court can issue writs in case of involving only fundamental rights, and the High Courts can issue writs otherwise as well, not only fundamental rights, even in other things also the High Court can issue the writ petition, okay, which is comes under your writs jurisdiction. Okay, so next one is High Court. See, appealing means simple, okay, it's appellate jurisdiction only High Court has, because when verdict given by the High Court means the appellate jurisdiction will go to the Supreme Court. So all these details comes under your Supreme Court of India. Next, High Court of India. The institution of High Court originated in India in the year of 1862. Which year? 1862. When the High Courts were set up at Calcutta, Bombay and Madras. These three places were popularly known as presidencies under the British. So 1862 is the first time in the three presidencies High Court of India came into existence, okay, under the British rule. The fourth one was established at Allahabad in 1866, and subsequently in all other provinces in British India, then they were called as states after independence. Okay, earlier during the time of British rule, federal means center, provincial means state. So around 11 provincial states came into existence in India during the time of 1930s. Okay, so this 11 states also got their High Court, respectively states. Now we used to call it as states. Okay, at present there are 24 High Courts in the country. Out of them, 3 are common High Courts. Okay, 3 are common High Courts. Delhi is the only union territory that has the higher court of its own since 1966. The other union territories fall under the jurisdiction of different state High Courts. For example, Andaman and Nicobar Island, union territory will come under the control of Chennai, High Court. Okay, likewise. So, appointment of the High Court judges. The judges of High Court appointed by the President. The Chief Justice of the High Court is appointed by the President of India after getting consult with the Chief Justice of India and also Governor of the respective state. For appointment of other judges, the Chief Justice of the concerned High Court is also consulted. Okay, while appointing other judges in the High Court, even they will consider the recommendation from the Chief Justice of High Court as well. In case of common High Court for 2 or more states, we can call it as Chandigarh. Chandigarh as common High Court. The governors of all states concerned are consulted by the President. For both the state governors supposed to be consulted by the President while appointing the judges of that combined High Court. Qualification of judges of your High Court. He should be a citizen of India. He should have held a judicial office in the territory of India for how many years? 10 years. Okay, he should have been an advocate of High Court or High Court in succession for how many years? 10 years. Either he is supposed to be a lawyer in the High Court for 10 years or else he is supposed to be a judicial office holder in the territory of India for 10 years. Okay, oath and affirmation. Oath to the judge is administered by the governor of a respective state. In terms of Supreme Court, respective to the President, but here it's the governor of the state. And in his absence, some other person appointed for that particular purpose. Tenure of the judge, he hold office until he attains the age of 62 years. He can resign, the office by writing his resignation letter to the President of India. He can be removed from his office by the President of India on the recommendation of the Parliament. He vacates his office when he is appointed as the Judge of Supreme Court or when he is transferred in another High Court. So that time he used to vacate his office. Okay, so based on the Supreme Court and High Court, a few questions that we can discuss. Where did India get its concept of single order of court? Earlier, we do have Supreme Courts, but it is only on the presidencies. But later on, based on this Government of India Act 1935, the single order of court was established in the region of Delhi. That is, now we used to call it as Supreme Court. So, as per Government of India Act 1935, India gets its concept in terms of what? Single order of court. Who can remove the judge of Supreme Court? Okay, who can remove the judge of Supreme Court? I told you, only the President has the authority to remove the judge of Supreme Court. Not Chief Justice, not even the Parliament, Not even Parliament and the President. Only the President has the authority to remove the Judge of Supreme Court. Next question. In which year NGAC, National Judicial Appointment Committee, was commenced? 2015. Okay, 2015 this NGAC came into existence along with the collegium system. What is the strength of Supreme Court judges? Current strength of Supreme Court judges, it is 32. Okay, one Chief Justice of India, other 31 judges in the Supreme Court. So total in number 32. Okay. How many high courts in India? We have how many high courts? We have around 24 high courts in India. Okay. So just practice more number of questions based on the judiciary. Go through the points whatever we discussed in this slide. Okay. So we'll see you in the next session. Thank you.